Okay, well, hello everybody, and thank you very much for joining this international masterclass on doing business in the US. I'm Nick Farmer, international tax partner here at Menzies, and I'm delighted to welcome along two good friends, and we've done a lot of work together over the course of time. Dave Springsteen from Withum, tax expert in federal, state, local taxes. Withum are one of our HLB partner firms, both East Coast and West Coast. Full service firm, a lot of expertise, and many of clients that we share together. And also Tobias Ziegler from Bressler Amery Ross, from tax or principal at the firm, covering legal matters such as immigration, tech, cross-border transactions. Doing business in the US is something that together we've worked with many clients on. So, guys, thank you very much for joining us on this this session. And just to put it into context to start with, I guess, I mean, the US is a massive market for UK companies. You know, it's the #1 country in the world for foreign direct investment. I think 9 years running. Massive market, 50 states, multiple time zones, a lot of complexity out there. And today, you know, with your expertise and help, we really want to explore the tax and legal issues. So we're not really sort of looking at politics or business climate. We're really looking at some of the things that can make or break someone's experience of doing business in the US. So the way we've sort of structured today's session is to move from a business that's trading from the UK into the US, what sort of issues they'll be facing, and then a business that's made the decision to set up in the US, what do they need to think about? And finally, once you're there and you're landed and you're doing business, what are some of the ongoing things that you need to think about? We've had some questions in advance, and everyone's very welcome to send in any Q&A, put it up on the chat. We'll see if we can cover some of the topics as they arise. But Dave, to get started really, and some of the questions that we've had are all around trading into the US and some of the issues that companies are facing. And there's this term that comes up sort of time and again, Nexus, and whether someone is exposed to US taxes. Perhaps you can sort of give an understanding of what this really means.
Sure. Greetings from the US. So Nexus is a US state concept. And so as Nick alluded to, the federal government has its own set of rules. And then we've got 50 states that have individual taxing rules. And within the state rules are state and local direct taxes and sales and use taxes, indirect taxes. But to determine if your inbound operations, if your inbound selling into the US is subject to any kind of taxation, we have to analyze the nexus. And nexus is a broad term that the states have defined individually. But when you boil down to it, the easiest concept, do you have physical nexus in any state in the US? Physical may be an employee. It may be an office. It may be inventory. Tangible things you can touch that are located in the US. But it's broader than that now, since the internet has kind of driven economic growth in the US from foreigners. It also includes what we call economic nexus. Are you generating revenue from a state, from your clients, from your customers, from a state that exceed a certain dollar threshold or number of transactions? Economic nexus has nothing to do with physical nexus. So you could end up having obligations to a state because of economic nexus. And Nick, if you just give me another moment, there is other types of nexus you could have. And that is what we call affiliated nexus. Affiliated nexus, if you're selling through a third party using their website to solicit orders for your product or services. That can also create nexus. There's also the latest and greatest, what we'll call a market facilitator, like an Amazon, where they advertise your goods, broadcast your goods. So Nexus is one of the things we address not only for local sellers, but also foreign inbound sales transactions, be it physical goods or electronic books or training or whatever. So that's the short story of Nexus.
Okay, let's try and unpack that a little bit with a few questions that have come in, because a lot of them have sort of come in around this this topic. Let me read through this one, and this might be quite a useful one. It says, without a legal entity in the US, could you help outline the steps to understand whether one has sales tax nexus in the US, including the extent to whether the location of pricing decision making and the ability to sign contracts is important or not?
It's a great question. It's a loaded question, and I think we can answer that within 2 hours. But here's what happens for remote sellers. You first need to define, am I subject to sales and use tax rules, the equivalent of VAT? Or am I subject to direct income tax? Now, from a sales and use tax standpoint, the Nexus rules are very, very broad. And we've had this court case, Supreme Court case, was also handed down in the Wayfair case, meaning that if you're selling into a state remotely, like I said, no people in the state, no inventory in the state, no office in the state. But if you're selling remotely from the UK, and if your sales exceed a certain dollar threshold, like Nebraska's 100,000, California's 500,000 US dollars, or if your number of transactions exceed 100 or 200, depending upon the state, in a year, you could be subject to sales tax in the US.
Dave, on that point, a UK business is no different from a US business. This applies to any UK business selling into the US, the same as a US business selling across state boundaries.
Right. Pretty much. Anytime you cross the borders, you've got to look, or what I say, know before you go. What taxes, what administrative issues will you face by having a client in New Jersey, in New York?
Yeah, so
good.
I was going to say, this is obviously a big thing for UK companies because we're not used to dealing with state taxes. We're used to dealing with a countrywide tax, but a state tax, you've got 50 different states, all that have got different rules, different thresholds, and very sort of complex tax administrations within them. How does a UK business actually, know what these thresholds are? I presume, they need to sort of keep a good track on where their sales are going, and if they're making multiple sales or high volume sales into a state, they need to get that local advice.
Yeah, as you know, Nick, we've worked on a lot of mutual clients coming into the US, and like I said, know before you go, and we see a lot of inbound clients doing their own research on the internet. And while they'll get to that threshold number, my recommendation, again, as know before you go, reach out to people like Tobias, myself, Nick, to get the real practical advice, the experience on how states will look at your transaction in particular. We spend a lot of time doing what we call Nexus studies. And it's not just today, the startup phase, where a lot of clients from a practical standpoint will say, all right, I'll wait for 6 months before I come into compliance. But at the end of the day, you need to know what your exposure will be going forward.
Yeah.
Good.
And moving on just to these withholding taxes that can arise, because we have a couple of questions around that. One which probably sets the scene, withholding tax. What's that all about, and why do so many overseas companies fail to understand that we have no establishment in the US?
Yeah, it's a good question. Again, the whole tax regime deals with a withholding tax. The U.S. is a flat 30% withholding on services and some other intangible revenue generating items, not necessarily from physical goods. But at the end of the day, if you have a customer in California, one, they look at the federal mandate for withholding taxes, and two, they've got to look at the California rules. So once again, we only generally hear about withholding at the federal level, but you also need to look at state level. And you're probably going to get to a point where we get this owner's form, the W-8-BENE, which often is requested by a U.S. customer before they make payments to a foreigner to either reduce or eliminate this withholding tax you're talking about. So at the end of the day, we need to understand what you're selling into the U.S., if there's going to be withholding, and how do you reduce that withholding tax?
Yeah, so just one final question on that, which again, I'll read through. It says, I've just got my first client in Pittsburgh, and I'm close to a deal with another in Kansas, and I provide online training services remotely from London. Do I need to do anything apart from get an EIN and filling in a W-8 BENE for each client? Is there an annual return that I need to do?
Okay, great question, and congratulations whoever asked that question coming into the U.S. And here's what's going to happen: the recipient of your wonderful training will probably ask for W-8 BENE, and you would probably complete that with the appropriate information. And as you know, Nick, there might be a reduced rate on any withholding from the U.S.-UK tax treaty. But what we would need to do is first, as I said, understand, do you have Nexus by remote training? Then we'd have to look at, is training subject to sales and use tax? And many states will say certain types of training is not subject to sales and use tax. That's the best answer that we can have here. Now, because you don't have physical Nexus, we then dive down into these two states, Pennsylvania and Kansas, to see if foreign provided training trips the direct income tax rules. So it's hard to give you an answer off the top of your head because we have a tremendous state and local team just to address all these rules.
Yeah, no, I understand that complexity. And we've been focusing on the tax here, but Tobias, just to bring you in, UK companies, no presence in the US, just trading from the UK with US customers. What are the sort of things that may catch them out from a legal perspective that they just need to be mindful of?
Yeah, thanks, Nick, and thanks again for having us. In your example, if it is truly a situation where a UK company is selling exclusively from the UK into the US, it is indeed conceivable to not have a US entity formed here. The moment, however, you have a, let's say, physical presence in the US, an employee, a physical office, which is quickly going to be, in our experience, a necessity. Online services may be an exception, but even there, over time, usually you do want to have a physical presence in one way or another in the US. The moment you do have that physical presence at the latest, we usually recommend forming an entity, because to the extent that you don't have a US entity, you're really exposing the mothership where typically the assets of the parent company are located to, for instance, litigation in the US. It is a litigious society, but I think and that's what Dave and I are here for, if you structure your business the right way, you can come away without tremendous cost or effort and building a series of shields that allow you to conduct business safely in the US. And those shields typically are, one, forming a US entity, which, if its formalities are being respected, will cause any lawsuit, for instance, to stay in that example, be limited to the value of the assets of that entity, as opposed to whatever the foreign entity has. So in other words, a lawsuit would have to be brought against a US entity. And then, you do have to have proper agreements in place between you and your customers, which give you additional protection. And then obviously you need to have proper insurance coverage. Those are the three typical classic layers of protection that you should have in place. And it's probably a good idea in most cases. Again, everything is fact specific, of course, but to form that US subsidiary early on. It is not a great effort to do so. And in fact, to the extent that you don't do it, you will quickly have to register your foreign entity in the US, which is arguably almost a similar effort in terms of having to register, paying fees, yet you do not get the benefit of having that liability shield that I referred to earlier. So on balance, it is a good idea to consider this early on.
Yeah, and this mirrors a lot of what we've done together over the course of time, where we've had UK businesses that may initially find US customers and trade into the US, and because there's only a few customers, they don't set up in the US. But there's this moment, isn't there, where the sort of balance swings. They're doing more business in the US. It makes sense to establish an entity, maybe looking to employ people out there, or needing that entity for contracting with customers to sort of assist with the ease of doing business. So at that point, we always get into this conversation with you and Dave about what kind of entity should get set up in the US. There's a few alternative choices, typically the corporation or the LLC. Perhaps, Tobias, you can just explain that, and also perhaps just explain, why does everyone talk about Delaware?
Sure. Yeah, there's really, in 99% of all cases, there is really just two options here that should be considered, and that's the US corporation. Well, there's no such thing as a US corporation. Let's keep that in mind. It's always a state creature. So every state has its own type of corporation and its own type of LLC. But it's really those two entities that would be considered here. The LLC, both entities have the limited liability feature that I referred to earlier that gives you that liability protection as an owner of that entity. So to the extent that you're conducting business through one of those types of entities, you as the owner are not exposed in terms of liability as long as you respect certain corporate formalities. There's similar concepts, of course, in the UK. The LLC, however, by default, from a tax perspective, is what we refer to as a pass-through entity. So it will be disregarded for tax purposes when it comes to taxation of the profits of that entity at the end of the year. So the government will look to the owners of that entity for purposes of taxes. And it's also a slightly more recent structure. The corporation has been around for a very long time, the LLC not so much. So there's, in terms of precedents, case law, and the whole body of law that surrounds both types of entities, there's a little more solidity when it comes to the corporation. And therefore, from a legal perspective, still slightly, it is still less probable that anyone will ever, what we refer to as piercing the corporate veil, will be able to come after the owners of an entity in a corporation. It's still a tighter structure in that sense. It is also because of that additional precedent that we have with those entities, a certain predictability, clear case law, especially in Delaware. It is also more interesting for investors to get involved in a US corporation as opposed to an LLC. And Delaware, that's particular. You asked why Delaware. One part of the answer, Nick, is actually because lawyers know Delaware law best. That's probably not the answer you were looking for, but it's actually true. And I will just say, in our defense, there's good reasons for that because of what I just said earlier. Delaware law is very friendly, business friendly. It tends to favor the entrepreneur, and it is very clear and predictable. There's over 200 years of jurisprudence. You have very competent judges there. And that's actually important. You can go to other jurisdictions, and others have tried to catch up in terms of the ease of transacting, which is great in Delaware. States like Nevada and Wyoming have made great efforts to eliminate certain taxes, making the whole process less bureaucratic. But they are still relatively obscure jurisdictions. And that is a degree of uncertainty that you add to your business that you do not really have in Delaware, where things are predictable. Virtually every situation has played out already in the past. So for a business person, that is still very interesting. Again, Dave can talk about the tax side. You're likely not going to pay corporate income tax in Delaware. administratively, there's an ease of transacting with them, as I suggested earlier, and there's less bureaucracy. So Delaware remains a really good option. A corporation, especially for a UK investor, is in most cases the better option. There's another aspect that comes into play, which is the income treaty between the US and the UK. It's not always the right solution. Obviously, you have to look at the existing structures in the UK and how things fit together. But more often than not, and I think Dave will probably confirm, the best option for a UK investor expanding into the US is indeed forming a Delaware corporation.
Yeah, and I think, to some extent, you sort of dispelled the myth that Delaware is all about tax. Very much, there are legal reasons why people are using Delaware, and looking at the choice of entity. Yes, sometimes the use of a limited liability company does make sense. It is the right model to use, depending on the reasons for establishing the entity and who the owners are and the tax treatment that you're looking to apply. More often than not, if you're a corporation expanding into the US, establishing a corporation under US state law will give a very clear understanding of the taxing position between the two jurisdictions. And Dave, just to extend this further, a UK company then has decided to establish a corporation in Delaware. We may set up a holding company for that here and put it as a subsidiary. That corporation then decides it's going to have an office in Chicago. What does that mean?
Yeah, it's a great question, Nick. What I call the wow factor. I didn't know. And this is where we need to reach out to Tobias again, because the states have their own rules. If you've got Nexus, an office, then we may also have to get authority to do business in that state. And often we find those inbound clients that are going to do business or have Nexus in many states may have to get authority to do business in lots of states. So Tobias, I don't know if you want to weigh in on that, but to afford more legal protection, you need to do this. And some states are now imposing a penalty for the failure to get authority to do business in that state. Now, that's totally separate than the tax compliance. Because if you do open up an office in, say, Chicago, and miss the step on authority to do business, we would still have to register for a corporate ID number in Illinois. We would then have to also determine if there's sales tax on what you're selling, not to mention all the employment issues that might arise if you're hiring people or people are working there, even remotely. So there's a whole host, and we have a big checklist on the issues you need to address, but the authority to do business is big.
Yeah, and just flipping back to the actual incorporation of the entity, Tobias, a couple of questions have come in around cost of incorporation. In the UK, it's very simple to set up a company. Minimum share capital can be done in a matter of days, and it doesn't really cost a lot to establish the entity. How does that look from a US perspective? How long does it take, and what's the typical cost of establishing an entity out there?
Sure. That's I'm tempted to give you the lawyer answer that consists of saying it depends, and that's still in a way a good answer, but that's not the answer that is wanted here. So the reality is there are many instances where people come to the US to form a simple subsidiary, very straightforward. You have one single owner of that entity, whether it's the UK entity or even an individual, and everything is quite straightforward. In that case, we can limit the cost to an absolute minimum. And I would say you can, under those really simple circumstances, you can probably limit the total cost to something like $2,500, $3,000 to set the entity up with the articles of incorporation, the bylaws, the resolutions, apply for a tax ID, issue shares if applicable, and even probably do business registrations where necessary, what we just discussed, and pay the state fees for the incorporation. Now, once you have additional factors of complexity, like, for instance, a more diverse ownership of the entity, you get into additional issues that can quickly bring you in another dimension. In other words, if you need a shareholders agreement between partners who are co-owners, for instance, of the US business, that is in and of itself a rather demanding task. So it really depends, but you know, we're always trying to look at, there's not a single answer to that question. This is the cost in every case. And when it is very simple, as in my example, then we're going to keep it to an absolute minimum, and you can come away with very, very low fees.
Yeah, and just looking at that entity itself, and Dave, you'll have a view here, I think, from a banking perspective. Do you need local directors in there? Can it just be done purely with UK directors? What are you seeing? What's actually required in the US here?
Yeah, it's a great question, Tobias. Feel free to weigh in, but you can have foreign ownership of a US entity. Often all the directors and all the officers are also foreign, but it's a big caution that we don't want the foreign parent to also have some kind of nexus in the US. So independence is very important on their actions on a day-to-day or on board meetings. So the ownership can be totally foreign. But the problem is, the biggest elephant, if you're ready for it, is opening a bank account in the US.
Yeah.
And a lot of UK companies come into the UK because it's easier to do business with US customers with a US bank account. Well, as we know, globally, opening a bank account has really become a headache. And without a US person with a US address and a US ID number, it is very painful to open up a bank account. You know, Tobias could open up a company in 24 hours, but to get the bank account open, it could take months. So that's probably the biggest hurdle. And again, advanced planning is really needed to make sure you have the right people involved.
And Dave, that's no different. In fact, if you flip it into reverse with a US company coming into the UK, banking is a massive challenge. And of course, having somebody local who, you know, can represent the company and be there to be contacted if the bank need to, then that is a massive tick in the box. So that's always going to be a big issue. Tobias, coming back to you, because something we talked about a while ago was that immigration plays a big part here as well, that often a UK company expanding into the US wants to get somebody in there, one of its own people from the UK, to actually set up and run that business. But immigration itself, just like banking, is a big challenge.
It is, and it certainly recently has been. Just one word to the previous discussion, because I know that's always on people's mind. Keep in mind that in order to form a Delaware corporation, a single individual can do so. A single individual can form, for an individual, a UK person can form a Delaware corporation, be the sole director, the sole the president and secretary, the officer of the entity, and never set foot here in the US. So that is a possibility. Now, from a practical standpoint, obviously, things are very different. As Dave just mentioned, bank accounts are a real issue. And it's not even so much because of legal statutes, but really because of internal bank compliance policies, where banks are forcing themselves to be very diligent about this. But back to your question, a recent problem, in part because of the US political picture when it comes to immigration, including business immigration, has been very slow-moving and problematic in past years. And you add to this the COVID pandemic, immigration has been a real impediment to investment in the US, because a lot of our clients who come from overseas have a product, a type of service, some kind of business, and a culture along with it that they would like to carry over into the US. And for understandable reasons, they like to send over some of their key people in order to help the US subsidiary to take off. And that has been very difficult. Now, the typical options that you have in order to bring someone over here I would say number one, the so-called L1 visa, which is an intra-company transfer visa. There's a similar type of visa in the UK, in fact, where a US affiliate of a foreign company receives one of the executives and managers of the foreign parent company here in the US to oversee a team of people and conduct business at an executive or managerial level. There's certain requirements that come with that visa, but usually that is one of the best options that we have because there's no limit to the number of visas that can be given out under the L1 in any given fiscal year. And there's also no particular point in time during the calendar year where you have to apply for that visa. So you can do it at any time. You can even pay a accelerated processing fee, and you will get a guaranteed first answer to your application within 15 days. So that's one of the best options that one has. The other one would be an H1 visa, which is based on your education. You have to have at least a bachelor degree. The problem with that one is simply that there are only about 65,000 every year available. They are usually gone very quickly. There's 2 or 3 times as many applicants every year for that visa, which causes the government to literally conduct a lottery to determine who even gets a shot to be considered for that visa. And then they go through your application. And the most problematic part, however, is that once you obtain that visa, you will inevitably only be able to start as of October 1 of a given fiscal year. So the problem with that is that that's not how business works, right? If you have, on November 1, you have a need to bring someone over to the US because you want to start your business, and you're being told, well, you have to wait until October 1 of the following year to do so, that's not a practical solution in many instances. Then you have the investor visa, the e-visa, where typically the applicant needs to be a co-owner of the business, which sometimes is the case, but oftentimes not. If you want to send over an employee, that's not really an option typically. And a couple of other ones, depending on the circumstances. But that has been difficult, and but we've been able to help our clients in that regard, and we're very proud of the fact that we have successfully sued the government and which ended up, a judge ended up ordering the government to issue a visa to one of our clients, because oftentimes they're really being rejected in an arbitrary manner currently, and that is not acceptable. So that is an issue to be considered, but Dave and I, we're here to help. And we can walk you through these issues, but it is certainly one of the considerations to take into account here.
Yeah, and I think, sorry, I dropped off there a minute, but thank you for giving all that information on immigration. I think the key thing we see on business expansion is this need to make sure that you understand the timelines that are involved, the things that need to be done in the right order in order to meet when you want to start doing business in that jurisdiction. You need to work backwards to understand when you've got to start certain processes to actually be able to sort of get yourself set up. There's a lot of time and energy clearly involved in overseas expansion and making sure that you are going to set it up in a way that's going to give you the best chance of success. Dave, I think we're coming on to sort of employment matters now, and in the UK we have these distinctions between someone who's an employee and someone who's a contractor. If you've got a UK company that wants to start using contractors in the US, or a US company that's using contractors, it's quite a common structure. Do you run into employment tax issues with those kind of setups?
Absolutely, Nick. This is probably another big issue to wrestle with, to plan out your workforce. Let's pretend you don't have immigration visa issues, but I see a lot of UK companies engaging independent contractors. And often the responsibilities of that contractor are aligned and akin with employment. So at the end of the day, there's both federal rules, and you guess it, there are separate state rules to determine if a person's actions and control over those actions treats them as an employee versus an independent contractor. And so again, know before you go, we have a checklist, 20 factors that you can simply tick, 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 and that will give you better guidance on independent contractor status. And often what we find, we think they're independent contractors, but they're really dependent contractors. And once you're a dependent contractor, then you get into all these state issues again, Nexus and the like. The biggest problem is coming clean from an independent contractor status to move them to employment status could be quite expensive from payroll tax and fringe benefit standpoint.
Yeah, and can you explain a little bit about this concept of PEO, a professional employer organization? We don't really see too much of that kind of model in the UK, but I know in the US, the use of PEOs is pretty common. Can you just kind of explain the way that works, why people may use it, and any issues that arise from it?
Sure. It is an interesting concept. So you're hiring an independent company to, in essence, hire and pay your employees. It's almost like a dual employment arrangement where you have the ultimate say, but all the administration and people are on the PEO organization's payroll. So once you get down and analyze all the administrative functions and the benefits you might have to offer, it's sometimes easier to pay the PEO 10-15% fee to run your entire HR and payroll function. So it's growing. We have many large clients on a PEO situation. It's not necessarily right for a smaller company because you can get through some of the headaches with a payroll company to handle the payroll, but it is popular.
But I guess the issue with PEO is it doesn't sort of get you over a lot of the issues that we've previously talked around state and local taxes. If you've got an employee, okay, it may be on the PEO's books and they're in a state, how does that sort of look from a taxing perspective? I guess you've got some complexity there.
Yeah, let's just go back to that. If you truly had an employee on your payroll and they go into a state that creates Nexus, that's a corporate issue or an LLC issue. But you also need to help the employee address their state issues. And this might happen with service people that go into California for a week, back to New York for 14 days. They themselves may have payroll tax issues. They themselves as employees may have multi-state income tax obligations. So it gets kind of messy from that standpoint. And again, the PEO, if you go that route, may also create some form of nexus for you, despite all the advertisements that say, we'll simplify your approach, you will not have nexus, you will not have all this multi-state compliance. You still need to pull back the onion skin to see what duties they're doing that you control over.
Yeah, no, I get that. And a question that's come in, Dave, but it kind of goes back to a little bit earlier in the conversation, but I read it out because it may be sort of something just to clarify on. It says many UK businesses are small operators selling products online from the UK to consumers in all 50 states of the US, possibly via Amazon. Are we saying that those small businesses might have tax liabilities just because they ship to the US? And if that is the case, you know, what are these thresholds? I know we talked about that, but maybe just a little bit of clarification.
Sure. You know, to analyze this question to get a semi-correct answer, we first need to define, is there physical products involved? And if there's physical products, Amazon as a market facilitator will probably take care of all your sales and use tax obligations clearly. But under selling into states, there's a public law 86-272 that says if your mere connection to our state is selling product, tangible product into the state, that may not create a corporate or what we call a direct income tax obligation. So there is this protection that's still out there, and it's only for those that sell product, not services, not licensing, whole different animal. So if you decide to go from a market facilitator, come to the US, engage Tobias to set up your structure here, then we would still look at the same thing. Will you be using Amazon? Probably. If you start doing your own distribution, then the question is, do we still have the 86,272 protection? And if not, you'll have to file income tax returns. Your sales tax compliance is still there.
Yeah. So we've got these multiple layers and different taxes, haven't we? The state tax, income taxes, but we've also got the sales taxes and how they are being dealt with. And anybody who's trading from the UK into the US need to really understand those obligations, you know, whether they are ultimately will lead to liabilities or not is the bit that somebody's got to review. But you can't just ignore the US because you're not there and you're selling in from a distance. All these issues have to be understood, and you know, if you're trading through Amazon, you've got to make sure that the sales taxes and local taxes are being thought through carefully. Tobias, just finishing around the sort of setup, the topics that we were going to discuss here, intellectual property, and you know, sort of a UK company that's got some significant branding or trademarks, and it's expanding to do business in the US, and it's going to use those through a US subsidiary. What does it need to think about there?
Yeah, it's an excellent question. And just one word to confirm what Dave said earlier. It's just of critical importance when it comes to employment that one that you have the right agreements in place, because it's not what you call it. If you call something an independent contractor agreement, but it is being reinterpreted by the government as one that really should be considered an employment agreement because you're dictating the hours, because the relationship is exclusive, because you're providing work materials to the contractor, which is now an employee, you get hurt very, very badly. And we have seen cases where the government requires you to pay back all sorts of taxes, fees, interests, and penalties on top of it. It can be very expensive. So that's an area to really be careful and pay attention. But to your question, Nick, IP is equally important, of course. You've built successfully a brand, now you have to protect it, and you should do that on day one. In fact, the moment we've incorporated an entity, that's really one of the very first issues, sometimes even before employment issues, that we discuss with our clients. The kind of protection depends again on your products. We have obviously people that we're working with who sell tableware with wonderful patterns on it. You know, here we talk about copyright protection, maybe design patent protection, but in almost all cases, a business will have a name and very often a logo. And in those cases, what we recommend from day one is really to consider filing a trademark protection in the US for both the logo and the word mark of that business name. And that's because even if there's an existing foreign registration, let's say European registration, because the way the application process works is different, we usually recommend having a separate registration here in the US. Descriptions of trademarks in the European Union, for instance, and in Britain are fairly broad when compared to the US. And if we're using the same description of a trademark that is being used in Europe or in the UK, here in the US, then oftentimes it is if it is even allowed to go through by the trademark examiner and not rejected as too broad, then it really only affords you a very weak protection that is subject to challenge in court, which is why we recommend looking at that existing foreign registration and perhaps make it more succinct or at least more appropriate for US purposes so that you do have a protection that actually stands up to and holds up if it's ever being challenged in the US. So that in almost all cases is something we recommend, trademarks, and then depending on the other types of products that you have, certainly copyright and also patent protection.
Yeah, and I'll jump a little bit forward here because this sort of does link in with transfer pricing, and you know, where is the intellectual property around a group and what charges should be made for it. In the UK, you know, from a transfer pricing perspective, we look at the size of the group in order to determine how relevant transfer pricing is. Small companies trading with treaty countries like the US, if you're small, you've got less than 50 employees, less than 10 million euros of revenue, transfer pricing, you have an exemption from. If you're slightly bigger, it might be transfer pricing at light touch, and only if you've got more than 250 employees around the group, as well as revenues of more than 50 million, broadly are you going to have to do full transfer pricing. But Dave, in the US, there's no such exemptions. As far as I know, everybody's exposed to transfer pricing.
There is no formal threshold. Often startup companies may ignore it temporarily, but clearly the UK parent is moving intangible value to the US in some form. And often we will consult on the initial startup of a company. Here's where you look at management of the US company and workforce in place of the company. The function is actually performed in the US that has derived value from the UK. And so we know what the transfer pricing exposure and planning might be. Now, at the end of the day, Nick, as we're talking about rates, while the US rate is 21%, and then you've got state income tax on top of that, it's only more beneficial to move value out of the US in the form of some kind of transfer pricing agreement. So while you have a formal threshold, we often try to drive how do we keep profits in the UK.
Yeah, so transfer pricing in a nutshell is really looking at the interaction between the UK company, the US company, what that UK company is doing to support the US company, or it can happen in vice versa, but you're looking at the interaction between the parties, aren't you? As you said, the management time, the use of the intellectual property, any goods that are being transferred, what price should they be moved at? When you've got companies in a group, transfer pricing is always going to be a very sensitive issue from a tax authority perspective, to make sure they are getting their share of the overall group profit.
Sure.
And in the US, clearly no exemptions. So you have to think very carefully about the transfer pricing, albeit that there may be benefits in having the profit back in the UK. The UK historically has been a lower tax jurisdiction, currently 19% on the corporate rates, but going up to 25 from April 23 for companies with profits of more than 250,000. So to some extent, we might see a little bit of equalization around some of the tax rates, but often, it's a good way of making sure that the UK company, is the one that is receiving the lion's share of the profits, but in a very sort of open manner, because these are transactions that are genuinely happening between the companies, and it's down to the business to identify them and document them and make sure that they can support these transactions with the tax authority.
Right, and we're finding it very interesting these days in the movement of goods into the U.S. What is the declared value for customs and other duties versus what the transfer pricing is, especially if you want to keep profits offshore. So it's a whole different study and art.
Yeah, David. And just looking at the compliance in the US, I know it's slightly different from the UK. In the UK, we have formal need for companies to prepare financial statements, lay them at company's house. In the US, it's a process much more driven around tax, as far as I understand.
Pretty much, but there's an added benefit when you do kind of a transfer pricing analysis, or what we call now consulting. It helps clients understand how they operate between the US and the UK and other parts of the world. So there is other derived benefits. Like I said, custom duties might be one of them.
Yeah, exactly. And a question that's sort of come in, which maybe you can kind of give some indications from, around sort of the cost of compliance. I know this will go back to Tobias's answer earlier. It depends around the complexity of the business, etc. But what is the compliance that needs to be done? What are the deadlines that you guys have to work to for companies? Let's just have a think about what actually needs to be done in the US.
Well, like you said, Nick, it depends upon the complexity of the company, where the functions are being performed, So we would do an analysis and say, well, here's the biggest value drivers. So let's just identify this transaction and this transaction. Let's get comfortable. Let's do an analysis. Then if you want a report, we can build that on top. The biggest issue as you grow, the failure to have the appropriate transfer pricing documentation could result in a substantial penalty on the redetermination of profits. So it is worthy of a discussion, then a business decision from that, and that would include timing when we actually examine this. And hopefully once it's done, it can carry over in theory for a couple of years if the business does not change.
Yeah, yeah. So I think transfer pricing we've highlighted as a key issue, something for people to look at. And Tobias, incentivization was something that we talked about, and the way that sort of works in the US and the way that may be structured to incentivize employees. Perhaps a few sort of thoughts around that and what you're seeing on the ground there.
Yeah, thank you. Yeah, what we're seeing is, one of these concepts that originated in Silicon Valley and that are now really ubiquitous is the issuance of stock options in corporations. And by the way, to our earlier points of about the Delaware Corporation being the entity of choice, if you speak to venture capitalists in the US, they will give you a very clear, direct answer as to what kind of entity you want to see when it comes to investing, and that's a Delaware corporation. And that's not because they're lawyers, but because they have learned over time that it is indeed advantageous to be in a Delaware C corporation, where you understand how things will play out, how it organizationally works, and to some extent how the Delaware law works. So in those entities, typically you consider issuing stock options to your employees, because it is a wonderful tool to tap into top tier talent, which you otherwise would have to pay top tier dollar, which oftentimes startups don't have. Instead, you're issuing stock options to them where they can at a later time purchase at today's value of the company, which is in many instances low at the beginning, to buy those shares at that low value in a future where the company's value may have grown tremendously. You have the same concept in the UK. And in fact, very often with UK clients, we get the question, to the extent that we would like to issue stock options to our US employees, but stock options in the UK parent company, how does that work? The answer is it does work. But in this instance and anything else, as I'm sure David will agree, having to do with stock options, you got to be very, very careful, because as much as it is a wonderful tool to incentivize your employees without, again, coming out of pocket on day one, if it is not structured correctly from a legal and tax standpoint, it could really turn into a nightmare and achieve the opposite. In other words, if it's not structured correctly, the employee could get a terrible tax hit, and as a result, probably not stick around, which is, after all, the idea, to keep people believe in the future growth of the company, even though on day one they may not be making a lot of money. So that has to be done very, very carefully. If it is done correctly, you get the advantage of being taxed not at ordinary income rates, but rather on capital gains rates, which are pretty much half of the ordinary income rates. So that's what we see for corporation. If you end up in an LLC, and it's not unheard of for UK companies to have US LLCs, could also be part of a holding structure where on top you have that Delaware C corporation that we typically recommend, but underneath, for various business branches, perhaps joint ventures with other partners that you would like to separate out, whatever it is, that could be a holding structure. If you end up in an LLC, then you have a sort of equivalent in the form of what's called profits interests. Similarly tricky in terms of structuring them correctly. You got to pay attention, but also a wonderful tool where you end up allowing the employee to participate in the growth, the value of the company in the future, and being taxed at capital gains rates. Without that employee, by the way, becoming an owner of your company. That's perhaps a key difference for stock option holders, to the extent that at some points they will exercise the option and therefore become a common share owner of the company. They are an owner of the entity with certain restrictions in terms of the ability to sell attached. But That's one of the key differences. But those two concepts come into play, and they're wonderful tools, but you got to pay attention.
Yeah, yeah, and I know actually the three of us have worked on a sort of similar transaction of this type, where we've had a UK company that's wanted to put a holding company on in the US in order to raise funds in the technology sector, and issue options to its staff, and all of that can be achieved, but you've got to go through those steps carefully and make sure, if you're looking to incentivize your staff, that you get the options structured in the right way and deal with the federal and the state taxes. I'm aware, guys, that we're coming up to half past. Just got a few minutes left, and I think Sam's sitting in the background here. We've got a poll we just wanted to launch. We've covered an awful lot of content here. I'd be very interested, people listening out there, if there's any particular areas that you feel you'd like to get more advice around, things that have really sort of interested you from the conversation. There's a lot of issues there, but I think the key point that we've been trying to make here is that you do need to get the support. Local advice can really make or break your US experience. Tax and legal are key components of that, and therefore, when you're looking at doing business in the US, please do reach out, and these are the sort of questions that we can help you to think through. So, Sam, I don't know if that poll has got any results that we can see.
That was launched. We'll end the poll now, so you can see the results.
Okay. So, Dave, that doesn't surprise me from what we've been talking about. State and local taxes. It's clearly a massive issue for UK businesses. A lot of complexity there. A lot of can give rise to some quite confusing sort of issues for UK businesses. And I know, your firm, you have people that all they do is state and local taxes. That's their, sole sort of focus. So it's a big issue. So yeah, definitely that's no surprise. So chaps, thanks so much for your time. I think we're bang on half past. It's been a pleasure talking through those issues with you. Everybody out there that's listening, thank you so much for joining us. I hope you found that conversation useful. And I think, Sam, we have just a slide with people's contact details if anybody does want to get in touch and to follow that up, or maybe we're sending that out afterwards, actually. So
we'll send that out on a follow-up. Yeah.
Okay, perfect. All right, well, we'll close the session there. Thanks again for joining us, and I wish you a good day.
Thank you all.
Yeah. Chat soon.